Assalamualaikum warahmatullahi wabarakatuh. Hi, my name is Nurul Ain Syuhada binti Umar Hisam. Today, I will explain about the crimes of aggression. So before we go to see the explanation about the war, about the crimes of aggression, we must recall that crimes of aggression is one of four crimes under jurisdiction of International Criminal Court, which the other crime is war crimes, crimes against humanity, and genocide. So, okay, first of all, let's talk about the history of aggression or crime of aggression. Okay, aggression in its action has been defined as a state's conduct that either initiates war against another state or bring about a situation in which the victim is or may be driven to the war. Up until the early 20th century, the waging of war was not prohibited under international law, and states could use war as a legitimate political instrument. The development of this crime can be seen at after World War II. The prohibition on the use of force by states was laid down in Article 2 4 of the Charter of the United Nations, which prohibit the threats or use of force against the territorial integrity or political independence of any states. However, these two exceptions were made. Firstly, is individual or collective self-defense by states involving the use of force is authorized by Article 51 of Charter, and secondly, the use of force can be authorized by the UN Security Council as under Article 42 of the UN Charter. Okay, after we know the history, we must know the meaning. So let's move to the meaning of crimes of aggression. So the definition of aggression can be seen in the Article 8 bis in Rome Statute of ICC, adopted at the 2010 Review Conference in Kampala. Based on the Article 8 of Rome Statute, it is stated the definition of crime of aggression is the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression which by its character, gravity and skill constitute a manifest violation of the Charter of the United Nations. In accordance with the United Nations Charter, an act of aggression is defined as the use of military force by a state against the sovereignty, territorial integrity, or political independence of another state. So, it can be said invasion, military cooperation, annexion by force, a blockade of the port or coast are only a few examples of this action. Next, let's talk about the elements of crimes of aggression in ICC. Okay, on this section, I will state about the elements. There are 6 elements in the crimes of aggression. First is the perpetrator is plain, prepare or initiate or execute an act of aggression. Second is the perpetrator was a person in a position effectively to exercise control over or to direct the political or military action of states which commit the act of aggressions. The third is the perpetrator was aware of the factual circumstance that establish that such a use or armed force was inconsistent with the Charter of the United Nations. Okay, for the fourth is the act of aggression is the use of armed force by states against sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of United Nations was committed. So next is the act of aggression by its character, gravity and skill constitute a manifest violation of the Charter of the United Nations. And lastly is the perpetrator was aware of the factual circumstance that establish such a manifest violation of the Charter of the United Nations. From these elements, there is such a state's act must amount to an act of aggression in accordance with the definition contained in General Assembly Resolution 3314, and it must, by its character, gravity, and skill, constitute a manifest violation of the UN Charter. This implies that only the most serious form of illegal use of force between states can be subject to the court's jurisdiction. Cases of lawful individual or collective self-defense, as well as action authorized by the Security Council, are thus clearly excluded. Alright, let's move to the next point, which is the 3 ways that the ICC can exercise jurisdiction. So, the crimes of aggression has a unique jurisdictional regime which cannot be triggered in the same manner as other with other crimes of Rome Statute, which is genocide, crimes against humanity, and war crimes. So, the court may exercise jurisdiction over crimes either by, first, is an ICC member state referring a situation to the court. Second is the prosecutor initiating in an investigation pro motu, which is it meaning on one's own initiative. And the third one is the UN Security Council referring the situation to the court. So above all of that, which is it, except in the case of the UN Security Council, refers non-ICC member states are excluded from the court's jurisdiction over the crimes of aggression regardless of victim or aggressor status. This case that I said earlier can be referred on, which is first in the case of a state's referral article 15bis, the court will only be allowed to exercise jurisdiction if the amendments have entered into force for at least one of the ICC member states, the victim of aggression involved. So the prosecutor must then determine there to be a reasonable basis to proceed with an investigation. If it is occurs, the prosecutor must notify the UN the Secretary General of the situation. The Secretary Council itself has the authority to determine whether an act of aggression has been committed. The prosecutor must allow the Security Council 6 months to make a determination. If no such determination is made, the prosecutor may still proceed with investigation only with the authorization of the pre-trial division judges. Alright, I'll move to the last point, which is how does the ICC exercise its jurisdiction? So, a state's adoption or ratification of the modification regarding the crimes of aggression result in their entry into law for states 1 year later. So, it is possible to opt out of the court use of its jurisdiction in cases where the UN Security Council has not referred the case, even if ICC member nation exercise their right to do so. According to the reported position of the majority of ICC member states, regardless of individual ratification status of the amendments, the court's exercise of jurisdiction over the crimes of aggression applies to all ICC member states, which is unless an opt-out declaration has been submitted on the two requirements ratification by at least 30 ICC member states and the decision by the ASP are met. And also the last is another viewpoint that only ICC member nations that have accepted the modification are subject to the court's exercise of jurisdiction over crimes of aggression.
Alright, last but not least is about general principles and other provision of the ICC statutes of the crime of aggression. So, it is difficult to immediately apply the modalities of participation outlined in Article 25, paragraph 3 of the International Criminal Court Statute, since aggression is a leadership crime that often involves the preparation of aggressive acts and the means of carrying them out. So, for the same reason, Article 28 of ICC statute, which is its refer to the as higher duty, which is appear to be improper. So, in order for the ICC to decide whether or not a state is responsible for a crime, international law defense like self-defense need to be admissible. But however, this will be defense to the collective act, not to the individual act of participation, and therefore will not easily fit inside Article 31 of statute. Moreover, the collective act will be prosecuted.
So that's all for me, Nurani Shada Bitu Hisam. Thank you.